Hi, what's up, perps? Um, I've been going down a bunch of rabbit holes today, so you guys kind of bear with me. Um, we are going to do a screen share. This is an episode of Paper Cuts. I think this is 47. I'm going to have to go back and check. But we have the This is the Way cut. And I know it looks screwy on the camera, but yeah, it always flips things around. So this is the way. Um, let's look at this because this is a red flag law that was introduced last year. And some people are going to ask me, well, Coot, why is this relevant since it was introduced last year? Haha, let's take a look at something. So let's do a screen share as always, like we normally do. I didn't turn my music on. We'll be all right. So let's shrink this down. I've got a ton of tabs open because I've been pouring through so much stuff. Like I said, it's been a rabbit hole day. So this is 3480 Extreme Risk Protection Order Act of 2021. Now, one thing I want to show you about this is let's look at co-sponsors. Since this was introduced on in early 2021, early to mid. But let's look at this. So when we get down here to co-sponsors, when we get down to the final or the last or the latest co-sponsors, look at the date they signed on. 5/27/2022. The nearest one before that was 5/17/2022. I believe that was right around the supermarket shooting or the grocery store shooting. Before that, we had 4/11/2022. Then we had 3/30. Then we had 1/10, 11/30/21. So this is still being signed on to. It's the 28th. So yesterday, Friday, there were people signing on to this red flag law. Now, much like I always do, and let me show you just because we're looking at it. I use Cornell Law whenever I want to go in and look at these different laws. It's a very reputable site, nothing off like Wikipedia or some BS like that where someone can go in and just edit things. I try to keep things, if I can't find it on Cornell Law, one, it probably doesn't exist, but two, then I'll go to a .gov site and I'll find it. Because I want to pull stuff from sources that, like I said, aren't Wikipedia. They can't be edited by someone else. These are actual hard sources on the information. So, like I always do when I do these, let me slide back to this real quick. I tell you what, I'm going to move my big old butt up here for a sec. That way I'm kind of out of the way. Like I always do on this, what I did was I came in here, I take the text of the bill, and I copy that over, and then I go through it page by page, basically, so that I can really show you guys, if you hang out for the whole video, or even if you skim through, how this is going to be put together. So when I take this, I copy the whole text and I'll bring it over into a Word document. Let me throw this up. Now the first things we're going through in this is basically a grant program where the federal government is going to allot people money if they are performing these red flag laws like the government sees fit. Act may be cited as the Extreme Risk Protection Order of 2021. Extreme Risk Protection Orders, definition in this section, eligibility, the term eligible entity means a state or Indian tribe, so they're basically trying to cover every subdivision of authority. That enacts legislation described in subsection C. We'll get down here to C in a minute. With respect to the Attorney General, determines that legislation described in Clause I complies with requirements under subsection C1. So we've got to sit here and read this word salad and pick through it, which I know, guys, is boring sometimes, but you need to understand where this stuff is going to go. And I try to keep things decently up, and maybe you'll see my temper flare up every once in a while. So we'll see. Certifies that the Attorney General, state, or Indian tribe shall use grant for purposes described in subsection B2, allocate not less than 25% and not more than 70% of the amount received under the grant subsection for the development and dissemination of training for law enforcement officers in accordance with subsection B4. Oh, it's ridiculous how these things are written. If we didn't have so many BS laws in this country, our legal code would not be this diluted and crazy. But it is, so this is the world we live in, kids. Any gun law should basically come down to the same thing. Thou shalt not murder someone with a gun. That should be our entire firearms code right there. And then, of course, you could get into accidental discharge and stuff like that. You could get into first degree, second degree, just like any other homicide. But we have to deal with this BS. So, unit of local government, private entity located in state or territory, certifies to the Attorney General of local government or entity shall use grant for purposes not less than 25%, not more than 70% amount received for the development and dissemination of training for law enforcement. So they're basically taking about 30% of that money and they could shoot it up a bull's butt. Extreme risk protection order. The term extreme risk protection order means a written order or warrant issued by a state, tribal court, or signed by a magistrate or other comparable judicial officer, the primary purpose of which is to reduce the risk of firearms-related death or injury by doing one or more of the following: prohibiting the named individual from having firearms in their custody, control, owning them, purchasing, possessing, or receiving a firearm, having a firearm removed, or requiring the surrender of firearms from a named individual. Now, what we're going to see as we roll down through this bill is that basically anybody could put a red flag case against someone in this bill. They supposedly have to sign this as an affidavit. They have to swear to it. But most of the time, even in a lot of other cases where someone has to swear out affidavits now, they can always say, well, I thought that was the truth, so I wasn't lying. And there are very few prosecutions. I'm going to learn to talk one day, say it all the time, working on it. So there are very few prosecutions for someone actually swearing out an affidavit and lying on it. The term firearm, they go into that. I mean, it's all defined in U.S. law. The Indian tribe has the same definition, 34 USC, yada yada. That's a whole part of the legal definition code. Law enforcement officer, same, has a definition. Let's see, petitioner. The term petitioner means an individual authorized under state or tribal law to petition for an extreme protection order. So this is a person putting the order against you. Respondent, that is the person who has the red flag law placed against them. And then they go and they define state, District of Columbia, Commonwealth of Puerto Rico, unit of local government. And of course, they go through all the legal definitions for that. grant program established. In general, the director of the Office of Community-Oriented Policing Services of the Department of Justice shall establish a program under which, from amounts made available to carry out this section, the director may make grants to eligible entities to assist in carrying out the provisions of the legislation described. So understand, this isn't a national red flag law. This is a grant program to get state and localities to do the red flags. Excuse me. To enhance the capacity of law enforcement agencies and the courts of a state, local, or unit of local government, Indian tribe, by providing personnel training, technical assistance, data collection, social media, and other resources to carry out enacted legislation described in subsection C. Again, they want to monitor everything that you say. And if you don't think some of your posts on social media could be taken out of context, you really need to wake up. I guarantee you someone could take some of my social media posts or even my videos out of context and try to press a red flag law, because I'm not real big on the government. Now, am I a threat to any innocent person? Hell no. I have nothing that's going to hurt an innocent person. Someone trying to harm my family or my loved ones, on the other hand, well, I have a lot of issues with that. But getting back to this, anybody could take your social media out of context and could press a red flag law or red flag whatever against you. So, to trained judges, court personnel, health and legal professionals, and law enforcement officers to more accurately identify individuals whose access to firearms danger, causing them harm to self and others by increasing the risk of firearm suicide or interpersonal violence. Now, here's a question. If you know someone is going to harm themselves or others, or you have a large suspicion that someone is going to harm themselves or others, that person is not in a rational state of mind at that time, for the most part. Every state in the United States and every district, Columbia, whatever, already allows for you to have someone involuntarily committed. So if you think someone is suicidal or something along those lines, you can inform authorities that that person is in such a state, and you can have them committed and evaluated and possibly treated if it's cause for that. That removes the person from any situation where they could harm themselves or others. If you just take the pews away from somebody, they can use other tools to harm themselves or others. So, let's get back in section or subparagraph C. Develop and implement law enforcement and court protocols, forms, and orders so that law enforcement agencies and the courts may carry out provisions of enacted legislation described in subsection C in a safe, equitable, that's a damn joke, and effective manner, including through the removal and storage of firearms pursuant to extreme risk protection orders under enacted legislation. And wait, there's more. Raise public awareness and understanding of the enacted legislation described in subsection C, including through subgrants to community-based organizations. Where's my mouse at? Let's get down here. for training of community members so that extreme risk protection orders may be issued in appropriate situations to reduce the risk of firearms related death and injury. That line in and of itself, firearms related death or injury, you'd notice they only care about the firearm. They don't mention about just the death or injury. So apparently to them, if someone slits their damn wrists, well, that's, they just, decided to check out. If they use a firearm, on the other hand, well, that's how dishonest these people are about their arguments. And I'm trying to stay very calm doing this. I'm going to go through some other stuff in a little bit where I probably won't stay as calm. So yeah, we might have a little fun with it. Let's see. In general, they talk about training here, law enforcement officers, relevant federal, state, local. Let's see. Equitable administration. Bias-based racism, ethnicity, gender, sexual orientation, gender identity, religion, language proficiency, and classism in the use and administration of extreme protection orders. If that doesn't make your head hurt, nothing will. I want to know what you were taking for said headaches to keep them at bay like this. All right. Interacting with persons with mental illness or emotional distress, including de-escalation and crisis intervention. And believe it or not, I would like to see more focus put on something like that. Because we have seen lots of incidents where people with mental issues, crises, could have been dealt with a lot better by law enforcement and weren't. So, sometimes their hand gets forced. They have to defend themselves. I completely understand that. But there are some cases where they could have dealt with things a lot better than they did. Goes with anybody, I guess. All right, best practices for referring persons subject to extreme risk protection orders associated with victims of violence to social service providers that may be available in the jurisdiction appropriate for those individuals, including health care, mental health, substance abuse, legal services, employment, vocational services, housing assistance, case management, and veterans and disability benefits. Let's see. Consulting with experts. When they talk about consulting with experts, that's a whole nother story. So developing enforcement training required under subparagraph A. Seek advice from domestic violence service providers, including culturally specific, as defined in Section Violence Against Women Act of 94. Remember, the Violence Against Women Act, the VMA, just got stuck through again, and it had a lot of gun control issues built into it. Thank you, omnibus bills. Social service providers, suicide prevention advocates, violence intervention, community groups, working to reduce suicides, violence, including domestic violence within a state. Remember, these are all the people they're supposed to refer this person to. Now, if a person is in this state, referring them to someone is not going to help them. That's why you have things like involuntarily committing somebody. All right, incentives for the fiscal year 2022 through 26. Attorney General should give affirmative preference in awarding any discretionary grant awarded by the Office of Community-Oriented Policing Services. Jesus Christ, man. People, come on. How many federal agencies do we need at this point? State or Indian tribe enacted legislation described in subsection C. Authorization of appropriations authorized to be appropriated such sums as necessary to carry out this section. That's basically a blank check. Eligibility for extreme risk protection order grant program requirements. Legislation described in subsection is legislation that establishes. Hit the wrong button. Get back up here. All right. Legislation described establishes requirements that are substantially similar to the following. Petitioner, including law. See, this is another thing. The petitioner, including a law enforcement officer. That's anybody who is toting a badge and a gun or is enforcing some government regulation. Any of them could press a red flag law case against you. We already hit that they want data collection. Again, what do you think the data they're collecting is? Let's see. Legislation described. Law enforcement officer may submit an application to state, tribal court on a form designed by the court or state or tribal agency, describes the facts and circumstances justifying the extreme risk protection order, signed by the applicant under oath. So they have to swear out an affidavit on this, but yeah, they ain't getting prosecuted if they lie. Ain't happening. Individual named in the application for extreme risk protection order, as described in subparagraph A, shall be given written notice of the application and an opportunity to be heard on the matter in accordance with this paragraph. So let's see. So it says you have to be notified of it. Issuance of extreme risk protection orders, hearing. Upon receipt of an application described in subparagraph A of a request, an individual named in such application, the court shall order a hearing to be held within a reasonable time, not less than 30 days after the date of the application of request. That is one aspect of this. Now, let's see. All right, if the court finds that a hearing ordered under subclause I, which is basically what we just read, preponderance of evidence, which means they don't have to have a serious factual basis for this. They can just throw enough crap against the wall to see what sticks. In accordance with heavier evidentiary standards established by the state or Indian tribe, that the respondent poses a danger of causing harm to self or others by having access to a firearm, the court may issue an extreme risk protection order. Again, that's anybody can press one of these against you. Now, the duration. An extreme risk protection order shall be in effect until an order terminating or suspending the extreme risk protection order is issued. So, you get an extreme risk protection order against you. You have to spend, and you will spend, thousands upon thousands of dollars to fight this in a court, and then you may get your rights back. For a period of, or for a set period of time, so the judge could say it was at a certain period of time, you would automatically get your rights back. Good luck ever having that happen. Now, ex parte extreme risk protection orders. Ex parte meaning you don't have to be there. And you can bet this is the way a lot of these orders will go. You won't have any real protection or recourse in this. Upon receipt of an application described in subparagraph A, the court may issue an ex parte extreme risk protection order if the application for an extreme risk protection order alleges the respondent poses a danger of causing harm to self or others by having access to a firearm. Now, under this, they could technically just say that you were handling firearms in an unsafe manner, so you were a danger to yourself or others. Just saying the way that's worded. The court finds there's reasonable cause to believe or makes a finding in accordance to a higher evidentiary standard by the state or Indian tribe that the respondent poses a danger of causing harm to self or others by having access to a firearm. So basically, worded kind of like it was, just a higher evidentiary standard. Duration of ex parte extreme protection order. An ex parte extreme risk protection order shall remain in effect only until the hearing required under subparagraph C1, which is that 30-day hearing, but on an ex parte order, when you haven't even been informed of this until your guns are taken, good luck getting a hearing. Availability for return. All firearms removed or surrendered pursuant to an extreme risk protection order shall only be available for return to the named individual when the individual has regained eligibility under federal and state law and where applicable. So, in other words, in some cases, you won't get your rights back. Consent required for disposal or destruction. Firearms owned by the named individual may not be disposed of or destroyed during the period of the extreme risk protection order without consent of the named individual. Think they won't push for that consent? All right, notification. In general, state, tribe, court that issues an extreme risk protection order shall notify the Attorney General or comparable state or federal tribal agency as applicable of the order as soon as practicable or within a designated period of time. Notice they don't outline that period of time. Form and manner, submit a notification under subclause, electronic format, manner prescribed by the Attorney General, updates to database, notification under Clause I, Attorney General or comparable state or tribal agency shall ensure that extreme risk protection order is reflected in the National Instant Criminal Background Check System. You can bet your sweet little one that as soon as one of these orders is issued, you're going in that system, and regardless of whether it's BS or not, you are going to have to spend a very long time fighting to get your name out of that system. Additional provisions, legislation described in subsection, provide procedures for termination of extreme risk protection order. Provide procedures for renewal of an extreme risk protection order. So they can basically extend these things forever. Establish burdens and standards of proof for issuance of orders described in subparagraph 1 or in paragraph 1 that are substantially similar or higher than the burdens and standards of proof set forth in that paragraph. Limit the individuals who submit an application described, provided that at a minimum, law enforcement officers are authorized to do so. Again, we're getting to law enforcement officers pressing red flags against citizens. I'm sorry, but if this law enforcement officer knows nothing about me and just sees social media posts they don't like, they should not be able to take my guns, but that's where this is going. Never mind the fact that the last shooters that we have seen were known to law enforcement, and law enforcement just didn't do a damn thing about them. All right, we'll get into annual reporting, number of petitions. They've got to report that. The jurisdiction, individuals authorized, alleged danger posed by the respondent. number of petitions that orders that were filed, as well as number of such orders and numbers denied, the jurisdiction, individual authorized, alleged danger posed by a respondent, number of petitions of renewals of extreme risk protection orders, as well as the number of orders issued, number denied. This is just all the reporting section. Demographic data of petitioners, demographic data of respondents, race, ethnicity, national origin, sex, gender, yada yada, all that's in there. Number of firearms removed if that is available. Federal firearms prohibition. So we get into 922 here. I've got that up. This is another one of these just insanely long bills. So we get into 922, which is unlawful acts. Snakeity. I seriously got to take him out, let him go a little bit. I'm going to let him go in the fig tree. Alright, so unlawful acts. So it would be unlawful for someone who is subject to a court order, primary purpose of which is to reduce the risk of firearms related death or injury, prohibiting such person from having under the person's custody or control, owning, purchasing, possessing, or receiving any firearms, provided that the order is issued in a manner consistent with the due process rights of a person, which is absolute crap, because if you take someone's rights away before they are convicted of a crime, there's no due process there. Is based on a finding that the person poses a danger of causing harm to self or others by having access to a firearm. Again, they don't list what types of harm. Then they come down here. Let's look at it in the bill. So they add this in. So this again, unlawful acts. Who has convicted of a misdemeanor crime of domestic violence, to ship, transport, and interstate or foreign commerce. Again, that's what all these bills are laid out on, and that's their foundation is interstate or foreign commerce, or possess and are affecting commerce any firearm or ammunition to receive a firearm ammunition which has been shipped, transported in interstate or foreign commerce. Are we getting the commerce clause in this yet? Is subject to a court order, the primary purpose of which is to reduce the risk of firearms related death or injury by prohibiting such person from having under the person's custody or control, owning, person, purchasing, possessing, or receiving any firearm, provided that the order A is issued in the manner consistent with the due process rights of the person, which is, again, we've already went over that. These things have no due process. B is based on a finding that the person poses a danger of causing harm to self or others by having access to a firearm. You guys tired of this bill yet? And this is just one of the red flag laws that I've covered in the last, I don't know, a few months, 5 months, 6 months, probably 5 months now. Alright, so we get through all that BS. Identification records. I'm not even going to pull up the edit on this. I'm so tired of these people. And now I've got tons more bills that I have to get into. So they get into 534 United States Code. Hell, let's just put it up. 534 United States Code. So this is a short section of code compared to others. So they get in here, subject to paragraph B. This is again illegal. Acquire, collect, classify, preserve records from tribal, federal, state individuals. Well, this is record keeping. Extreme risk protection orders as defined. Yada yada. It would be illegal to destroy each record acquired under subparagraph A when the applicant is extreme risk protection order. Well, this would They have to destroy them when the order's terminated, basically. I'm getting a little backwards here. So that became paragraph 4, then paragraph 4 became paragraph 5, then they add in 5A down here. And then they add this in at the end of this. Extreme risk protection orders in a national crime and information database, a federal, tribal, state criminal justice agency, or criminal civil court include extreme risk protection orders as defined in subsection 2, which is all that stuff we read up there. Order Act of 2021, National Crime Information Database, as the term defined in F3 of this section, which is yada, have access to information regarding extreme risk protection orders through the National Crime Information Database. Good Lord. And people say there aren't enough gun laws. And this is going in editing the existing stuff and just throwing more crap on the big pile of crap that's already there. So I'll just make the pain stop already. Alright, conforming amendments, section 3.1, Nix Improvement Amendments. And yeah, I went through that. They basically take out section 922G8 and add in all the crap in 922 that they edited. So all that becomes part of it. Full faith and credit. Hey, there is no faith in this bill. Alright, definitions. Full faith and credit. Any extreme risk protection order issued under state or tribal law enacted in accordance with this act shall be in accordance the same full and faith credited by the court enforcing state or Indian tribe and enforced by the court and law enforcement personnel of the state or tribal government. Oh, good Lord, man. It is insane trying to read this stuff. So it's basically one big grant program to tell the states, we are going to give you this free money if you just go out there and take people's rights. That's exactly what this amounts to. Let's look at this. This is another ex parte thing. Ex parte protection orders for the purpose of paragraph 1B in the case of an ex parte protection order. Notice and opportunity to be heard shall be provided within the time required by the state or tribal law, and in any event within a reasonable time after the order is issued sufficient to protect the due process rights of the respondent. Notice they do not list a time frame for that in this section, which would basically give the state, tribe, local government the authority to make that time frame up as they go. And we all see how issuing even concealed carry permits in some places, they have strung that out, and even when they have a time frame like 30 or 60 days, they have strung that out for months and months and months or years. Think that won't happen with this. Alright, this is the end of it, kids. Everybody clap, yay, golf clap, whatever. We all survived. Well, most of us did. If any provision of this act or amendment made by this act or application of such provision to any person or circumstances held it to be invalid, the remainder of this act or an amendment made by this act or the application of such provision to other persons or circumstances shall not be affected. So in other words, if we started picking this apart and basically getting it ruled unconstitutional on each piece, no matter what we did, we would not get this overruled until every single part of this was found to be unconstitutional. Everybody take a breath. And realize this bill is still being signed on to as of yesterday, like we went over at the start of this, and it will continue to be signed on to. And there are more bills just like this. The Senate bill is still there, and the Senate bill is going up. And recently, within the last little bit, more bills like this have been submitted. If you think they are not coming after you,
You do know you sound like a psychopath, right?
oh yeah, I do kind of sound like a psychopath.
You sound like a paranoid schizophrenic.
Well, in this world, it is not whether you are paranoid; it's if you are paranoid enough. Apparently.
Saying.
So anyway, that's this bill. That's this red flag bill. One of these days, I'll probably have to do 10 videos a day to actually catch up to where these guys are at right now with all their other gun control proposals. So we'll see. It really sucks that I have so much content to work with. Believe it or not, I would rather be out doing videos on something else. Macrame. Macrame is fun. But instead, here we are. So anyway, I'm out, guys. Y'all take them easy. Y'all be cool. And we'll probably do another one here in a little while. Later.